So to begin here, as I said before, if you want to actually get the opinion and actually read the actual opinion, go to the source. Go to the website for the Supreme Court of the United States, supremecourt.gov, and pull the opinion down that way. All right? I don't care what source you get it from. Like, if you want to know exactly what the opinion is, go to the actual Supreme Court website. This is the Supreme Court website. This is the opinion. So, at the outset, I need to say that I am attempting to do this in a completely non-political, non-policy driven analysis. I am not here to debate whether this law was a good idea or a bad idea. And actually, that's not what the Supreme Court was trying to say either. No matter what you think about the Supreme Court, and obviously the court has become politicized in the past decade, 12 years or so, more so than it usually has. When a case comes before an appellate court, the job of the court is not to decide whether this law was a good idea. Its sole job is to decide whether this law passes muster when put up against the Constitution and other statutes. It could be the worst idea in the world, but as long as it comports with the Constitution and it was properly passed by Congress, signed by the president, that's all the court is there to decide, even if it is a terrible idea. Like, so for example, if Congress wanted to tax every American at 98% of their income, they could probably do that. It would be a terrible idea, but it wouldn't be the Supreme Court's job to shut that down, even though it would completely destroy the United States economy. It's not the court's job to say, well, that's a really stupid idea. We're going to say that you can't do it. Not the court's job. If it comported with the Constitution and it was lawfully passed, the court's going to say, all right, go ahead, shoot yourself in the foot, Congress. So I am not here to debate whether this was a good idea or a bad idea. I'm just here to give a legal analysis of why the court found the way they did. One thing to note here is that this is a per curiam opinion. That's unusual because the court rarely issues a per curiam opinion. Well, what is a per curiam opinion? I need to find a case that actually I can show this. See, damn it, this was a unanimous. I need to find a non-unanimous opinion to show you how they normally do this. This is the Corner Post case. I'm not going to talk about it. It's an interesting case, but so this is what you normally see, right? You'll see Barrett delivered the opinion of the court in which Roberts, Thomas, Alito, Gorsuch, and Kavanaugh joined. Kavanaugh filed a concurring opinion. Jackson filed a dissenting opinion in which Sotomayor and Kagan joined. So normally the court will issue an opinion and say who was on what side. They did not do that here in the TikTok opinion. It just says per curiam. Now, what's interesting here is that this is a unanimous decision. Every member of the court agreed that this law was in fact constitutional. And we know that because there are two additional opinions besides the per curiam, but when you come down after the per curiam portion, I don't remember what per curiam means in Latin. I'm sorry. I don't remember what it means in Latin. But basically what it means is that the court issues the opinion and doesn't sign it and doesn't say who was in what camp. But you come down here and it says Justice Sotomayor concurring in part and concurring in the judgment, which means she agreed with the per curiam portion, and then Justice Gorsuch concurring in the judgment. So this was a unanimous decision. It was just released per curiam, which means unsigned, and they don't say who was in what camp. And we also don't know who wrote it. It's just issued by the court, right? And I cannot remember what per curiam means in Latin. Sorry. Yes, I'm an attorney, but I never took Latin. So, but this is a unanimous opinion. So they begin by just summarizing that as of January 19th, which is the day after tomorrow, the Protecting Americans from Foreign Adversaries Controlled Applications Act will make it unlawful for companies in the United States to provide services to distribute, maintain, or update the social media platform TikTok unless operation of the platform is severed from Chinese control. It's important to note that this law did not say TikTok can't speak. This law did not say anyone can't speak. This law merely said, unless TikTok is divorced from Chinese control, it cannot be used in the United States. So if ByteDance had sold TikTok to any American company, Meta, Microsoft, people were talking about Elon Musk buying it, which none of that's going to happen, at least I don't think, then there would have been no change. The problem was ByteDance, the Chinese company that owns TikTok, would not allow TikTok to use its algorithm if it were not sold by or controlled by the Chinese government. Chinese government did not want to give up its intellectual property, the algorithm, and it would not allow any non-Chinese controlled company to use that algorithm. Many people have said, and they may be correct, that TikTok's algorithm is one of the best social media algorithms in existence and may be the best. And so why would the Chinese government want to give up their intellectual property and have somebody else use it? So I can understand, besides, the data collection, which we'll talk about later, and the ability of the Chinese government to A, spy on Americans, and B, promote propaganda, and not necessarily propaganda, but promote particular issues through its algorithm. And I'm not saying that as a judgment call. I'm saying that because that was the basis of this opinion. Okay. But besides all that, as a business strategy, ByteDance would not want to just let its algorithm go. And TikTok argued that without the algorithm, TikTok isn't as good and isn't what its users expect it to be, which was the reason why they never sold it. But ultimately, this case focuses solely on the Chinese control of the company. It has nothing to do with stopping any particular person from speaking. It's just, is this company controlled by China? So they talk about what TikTok is. Everybody, I'm going to assume that everybody watching this video knows how TikTok works and what it is. But they do talk about how each interaction a user has on TikTok, watching a video, following an account, leaving a comment, enables the recommendation system to further tailor a personalized content feed. A TikTok user's content feed is also shaped by content moderation and filtering decisions. It uses automated and human processes to remove content that violates the platform's community guidelines. TikTok also promotes or demotes certain content to advance its business objectives and other goals. What are those other goals? Don't know. TikTok is operated in the United States by TikTok Incorporated, which is an American company incorporated and headquartered in California. However, TikTok's ultimate parent company is ByteDance Limited, a privately held company that has operations in China. ByteDance Limited owns TikTok's proprietary algorithm, which is developed and maintained in China. ByteDance Limited is subject to Chinese laws that require it to assist or cooperate with the Chinese government's intelligence work and to ensure that the Chinese government has the power to access and control private data the company holds. This is the main substance of why this law was upheld, was this data access. And they do note there's a real complicated history of how we got here. In August of 2020, President Trump issued an executive order that tried to ban TikTok. He tried to invoke emergency authority under the International Emergency Economic Powers Act to prohibit certain transactions involving ByteDance or its subsidiaries. But federal courts enjoined the prohibitions before they took effect, finding they exceeded the president's power under this law. So there was one attempt to ban it. It failed. Just days after issuing his initial executive order, President Trump ordered ByteDance to divest all interest and rights in any property used to enable or support ByteDance's operation of the TikTok application in the United States, and wanted them to basically delete any data obtained or derived from U.S. TikTok users. Yet again, in February 2021, the D.C. Circuit placed the case in abeyance to permit the Biden administration to review the matter and enabled the two parties to negotiate an agreement that would address the government's national security concerns. So there were two attempts to ban TikTok. In February 2021, the Biden administration tried to negotiate with TikTok to develop some agreement that would resolve their concerns. It never happened. The executive branch officials ultimately determined that ByteDance's proposed agreement did not adequately mitigate the risks posed to U.S. national security interests. So they never came to an agreement. So then Congress enacted the act, and although the act itself does mention TikTok, here's the substance of the act. The act makes it unlawful for any entity to provide certain services to distribute, maintain, or update a foreign adversary-controlled application in the United States. So the act provides two means by which an application may be designated a foreign adversary-controlled application. First, the act expressly designates any application that is operated directly, indirectly by ByteDance Limited or TikTok or any subsidiary or successor thereof. But then it establishes a general framework where the president can determine that there is a significant threat to the national security, requires a public notice and reporting like a lot of administrative agencies. So while the act itself does in fact target TikTok, it also allows the executive branch to declare that a particular company or a particular service is in fact operated by or controlled by a foreign adversary. Now, it does give that particular foreign adversary the right to respond. It did not give TikTok the right to respond because they'd already done that. They'd already gone through a process and it didn't work out. So that's basically how we landed here today, right? The sole issue here is the ownership of the company. It's not what's said on the program, on the app or anything. Or at least that's not what the court decided this case based on. So we can talk, this goes through the procedural history. And the first thing they say is, at the threshold, we consider whether the challenged provisions are subject to First Amendment scrutiny. So a lot of people were talking about this and saying this violates the First Amendment because it's preventing people from speaking. But what they say here is that it is not clear that the act itself directly regulates protective expressive activity or conduct with an expressive component. Indeed, the act does not regulate the creator petitioners at all, because a group of creators that used TikTok also were a party to this case. It wasn't just TikTok itself. A group of content creators got their own attorneys and brought this case as well. They were joined together. But the act doesn't regulate the creator petitioners at all. It doesn't tell any creator on TikTok what you can or can't do. And it directly regulates ByteDance Limited and TikTok Incorporated only through the divestiture requirement. That's it. All it says is you have to sell. It doesn't say you can't say this. It doesn't say you can't say that. It just says ByteDance, TikTok, You got to sever that relationship. That's all it does. So again, I've read this before, but I'm gonna have to scan it as we go through, as we talk about it. So the petitioner's arguments approximate a claim that the Act's prohibitions, TikTok-specific designation, and the divestiture requirement impose a disproportionate burden upon their First Amendment activities. So basically what they're trying to say is you're singling out this particular speaker as opposed to other speakers and not allowing this particular speaker to speak. Petitioners assert, and the government does not contest, that because it is commercially infeasible for TikTok to be divested within the Act's 270-day time frame, the Act effectively bans TikToks in the United States. Petitioners argue that such a ban will burden various First Amendment activities, including content moderation, content generation. And this is the thing that hit me the most about this particular law. I did not believe that there was a speech problem with this because it treats all speech on the platform equally. Plus, it's not telling anybody you can't speak. It's just telling people you can't speak on this particular medium, right? So things will really run afoul of the First Amendment when you're attempting to regulate them based on their content. So, for example, if you were saying people with conservative opinions can speak, but people with liberal opinions cannot, that's a content-based restriction, and that almost never is sufficient under the First Amendment. That will almost always be thrown out. This law doesn't do that. It doesn't stop anybody from speaking. It just says, if you want to speak, you can. You just can't be controlled by China. So, but what I did think was interesting here was the association aspect. The First Amendment does protect the freedom of association. So basically, it's, if I were a TikTok content creator, I would say, well, I want to speak and I want to associate with this company, and I have a right as an American to freedom of association. The opinion doesn't really address that as much as I would like, because I personally believe that's the stronger argument that the petitioners had, was that you're saying we can't associate with this particular person. Although the opinion doesn't address that terribly much, I think it's clear, though, that they're basically saying the First Amendment, yes, may be impacted here, but the interests of national security outweigh any First Amendment issues here. And I think that's where the court comes out. And as they say here, a law targeting a foreign adversary's control over a communications platform is in many ways different in kind from the regulations of non-expressive activity that we have subjected to First Amendment scrutiny. Those differences, the Act's focus on a foreign government, the congressionally determined adversary relationship between that foreign government and the United States, and the causal steps between the regulations and the alleged burden on protected speech may impact whether First Amendment scrutiny applies. But then they say, and this is what Justice Sotomayor had a problem with, we assume without deciding that the challenged provisions fall within this category and are subject to First Amendment scrutiny. Justice Sotomayor's concurrence was, well, I agree in the result, but this is clearly a First Amendment issue. The law is fine under the First Amendment, so why did you assume without deciding that it was a First Amendment issue? That was really all Justice Sotomayor's concurrence said. It was like, I think we should have just said that this is the First Amendment and this law survives First Amendment scrutiny. But they go into history, and as I was saying before, that content-based laws that target speech based on its communicative content, are presumptively unconstitutional and may be justified only if the government proves they are narrowly tailored to serve compelling state interests. Content neutral laws, in contrast, are subject to an intermediate level of scrutiny because in most cases they pose a less substantial risk of excising certain ideas or viewpoints from the public dialogue. Historically, the Supreme Court has used what they call 3 tiers of scrutiny to determine whether a law passes constitutional muster. These tiers of scrutiny may kind of be going away, but that's a discussion for another time. Because they did look at scrutiny in this case, I'll explain. The lowest level of scrutiny is a rational basis review. Basically, that is, yes, this may impede upon people's rights, but as long as the government has a rational basis for passing this law, we will say it's or we will say that it is constitutional. The next tier is intermediate scrutiny, which is what we just talked here, which is basically has to be tailored to serve an important governmental interest. But the highest level of scrutiny has to be narrowly tailored to serve a compelling state interest. Lawyers basically look at it like this. If it's rational basis, the government always wins. If it's strict scrutiny, the government almost always loses. Intermediate scrutiny, flip a coin. So one of the things that the court is trying to figure out here is this intermediate scrutiny or is it strict scrutiny? They basically are saying that they basically get to the analysis that it's intermediate scrutiny. So, and as they say here, the challenged provisions are facially content neutral. So there, ding, there's the way that we get to intermediate scrutiny. But as they say, they impose TikTok specific prohibitions due to a foreign adversary's control over the platform and make divestiture a prerequisite for the platform's continued operation in the United States. They do not target particular speech based upon its content, contrast, or regulate speech based on its function or purpose. I'm sorry, contrast was a signal, not part of the sentence. So they do not target particular speech based upon its content or regulate speech based on its function or purpose. So what they're saying is it's completely neutral. It's not stopping anybody from speaking based upon what they want to say. It's only stopping people from speaking on a platform controlled by a foreign adversary. And there was a footnote up here I need to go back to. Yeah. Okay, I see why that's a footnote. I'm sorry. But back to this. Now, there was a carve out in the law that did not affect applications or websites if the application whose primary purpose is to allow users to post product reviews, business reviews, or travel information and reviews. I know that would have affected a whole bunch of apps and websites that really didn't need to be brought into this. And so what the petitioners, TikTok, and the creators were trying to say is, well, this is content. This is a content restriction because if you're posting a review, that's fine. But if you're not, then you fall under the ambit of this. The court says we don't need to decide whether that exclusion is content-based because, and this is the way you analyze constitutional issues. The question before the court is whether the act violates the First Amendment as applied to petitioners. So when you try to challenge a law in the Supreme Court, you can either do an as-applied challenge or a facial challenge. The problem with a facial challenge is that in order to win a facial challenge, you have to say there is no universe, there is no situation in which this law could be applied to anyone and meet constitutional muster. As opposed to the as-applied challenge, which says this law, when applied to me, violates my rights. That's a much easier challenge to win instead of trying to prove that there is no situation in which this law could be unconstitutional. The court is only going to analyze an issue as it is brought to them. So the petitioners chose to make this an as-applied challenge as opposed to a facial challenge. And that's why the court says that here. We're only deciding whether this law is unconstitutional as applied to TikTok and the creators that sued with them. And here, this is probably the key. As the opinion goes on, this is probably the key to the entire opinion. The government also supports the challenge provisions with a content-neutral justification, preventing China from collecting vast amounts of sensitive data from 170 million U.S. TikTok users. That rationale is decidedly content agnostic. It neither references the content of speech on TikTok nor reflects disagreement with the message such speech conveys. Because the data collection justification reflects a purpose unrelated to the content of expression, it is content neutral. Then they answer again that the Act's TikTok-specific distinctions, moreover, do not trigger strict scrutiny. So, because they're knocking out the possibility of strict scrutiny, like if you're an attorney and you're reading this opinion, as soon as you see that does not trigger strict scrutiny, you know that the government probably won, right? And they did. And as they go on to say, for the reasons we have explained, requiring divestiture for the purpose of preventing a foreign adversary from accessing the sensitive data of 170 million U.S. TikTok users is not a subtle means of exercising a content preference. They are based on a content-neutral data collection interest, and TikTok has special characteristics. A foreign adversary's ability to leverage its control over the platform to collect vast amounts of personal data from 170 million U.S. users that justify this differential treatment. While we find, now this is important, while we find that differential treatment was justified here, however, we emphasize the inherent narrowness of our holding. Data collection and analysis is a common practice in this digital age, but TikTok's scale and susceptibility to foreign adversary control, together with the vast swaths of sensitive data the platform collects, justify differential treatment to address the government's national security concerns. A law targeting any other speaker would by necessity entail a distinct inquiry and separate considerations. No more than intermediate scrutiny is in order. As applied to petitioners, the Act satisfies intermediate scrutiny. The challenged provisions further an important government interest unrelated to the suppression of free expression and do not burden substantially more speech than is necessary to further that interest. That's the holding. And like I said, it has nothing to do with we don't like TikTok. It has to do with we don't like China. The Act's prohibitions and divestiture requirement are designed to prevent China, a designated foreign adversary, from leveraging its control over ByteDance Limited to capture the personal data of U.S. TikTok users. Even the petitioners did not dispute that the government has an important and well-grounded interest in preventing China from collecting the personal data of tens of millions of U.S. TikTok users, nor could they. And then they talk about this. Data collection practices extend to age, phone number, precise location, internet address, device used, phone contacts, social network connections, the content of private messages sent through the application, and videos watched. TikTok collects user content, behavioral data, including keystroke patterns and rhythms, and device and network data, including device contacts and calendars. If, for example, a user allows TikTok access to the user's phone contact list to connect with other users on the platform, TikTok can access any data stored in the user's contact list, including names, contact information, contact photos, job titles, and notes. So even though TikTok does not use your contact list, that's stored in a separate program. If you give it access to it, it gets the data on every person in your contact list. Access to such detailed information about U.S. users, the government worries, may enable China to track the locations of federal employees and contractors, build dossiers of personal information for blackmail, and conduct corporate espionage. And Chinese law enables China to require companies to surrender data to the government, making companies headquartered there an espionage tool of China. That's just a fact. And as they noted there before, the Chinese government requires TikTok, or any corporation owned by the Chinese government, requires them to participate in Chinese intelligence gathering activities. This is why the law was upheld. And I have a sleepy Frau in here.
I'll be quiet.
That's basically it. We can read the rest. You could read the rest of this opinion, but that's really the basis for which the court upheld this law. There were some discussions about alternatives, like putting a warning on TikTok that, if you use this app, your data is subject to being used by the Chinese government. But because it's a national security concern, that doesn't assuage the national security concern. So that's basically it. It had nothing to do with liking or not liking the app or what it was said. It was solely about the control. And as I discussed earlier, yes, TikTok could have been divested from Chinese control, but the algorithm would have been lost. And that is the moneymaker for TikTok. They're not going to allow TikTok to use their algorithm. And besides, the algorithm probably includes all of that data generation or data collection practices. That wasn't mentioned in the opinion. That is my assumption that that's part of the algorithm. So as I said, Justice Sotomayor basically said, look, I see no reason to assume without deciding that the act implicates the First Amendment because our precedent leaves no doubt that it does, right? But she still says, I agree that the act survives the petitioner's First Amendment challenge. I see Justice Sotomayor's point there. Why do you assume without deciding? That was like the whole point of the case. The court was basically saying, we're just going to assume that this is true, and even if it is true, it's still good enough to pass constitutional scrutiny. I do want to talk about Justice Gorsuch's concurrence, because honestly, it's probably the best part of this opinion. Because Justice Gorsuch, I'll just summarize his concurrence. He basically says, look, I'm pretty sure we're right here, but we didn't get, he says, we have had a fortnight to resolve finally and on the merits a major First Amendment dispute affecting more than 170 million Americans. His entire concurrence here is like, I really hope we made the right decision here because we didn't have enough time. He believes that even if strict scrutiny applied, that it would have passed muster. But yeah, and I love the part where he says here, whether this law will succeed in achieving its ends, I do not know. A determined foreign adversary may just seek to replace one lost surveillance application with another. As time passes and threats evolve, less dramatic and more effective solutions may emerge. Yeah, as he says, but the question we face today is not the law's wisdom, only its constitutionality. Given just a handful of days after oral argument to issue an opinion, I cannot profess the kind of certainty I would like to have about the arguments in the record before us. All I can say at this time and under these constraints, the problem appears real and the response to it not unconstitutional. But I do like, there's one part in here, let me find it. There was classified evidence pushed forward by the government in this case, but the Supreme Court didn't even consider it. He says, second, I am pleased that the court declines to consider the classified evidence the government submitted to us, but shielded from petitioners and their counsel. Efforts to inject secret evidence into judicial proceedings prevents obvious constitutional concerns. So the point here is that, yes, the FBI, the national intelligence community, gathered information about China, TikTok, and its operations in using classified means, classified methods, and they're not going to give that over. And normally in a case, if you want to use classified evidence, most of the time you can get it and you can see it. It's a long, complicated story. And I shouldn't have said most of the time, but there are ways that you could get it. But the point is, if you can't see the classified evidence, how can you defend yourself? How can you advance your case? The court here just didn't even consider the classified evidence, which is a good thing, because that would not have been fair to TikTok, or, well, really to TikTok. It wouldn't have affected the creators at all. So I'm glad that that was addressed, at least by Justice Gorsuch in this opinion. So that's basically it. And low-level chat, I see you. I see your text messages. What's the TLDR? The TLDR is the law was constitutional. TikTok may be banned, but it may be banned solely because it doesn't actually interfere with anybody's free speech rights. It only deals with the fact that it is owned by a foreign adversary, in this case China. Therefore, it's not discriminating against anybody's viewpoint, and the national security concerns of the United States outweigh any First Amendment concerns raised by this law. Was that a good TLDR? I hope so. If anybody in the chat has questions, I'd be glad to answer them now. If not, I'm going to be done and I'm going to go play some video games.